Please be seated. You can be seated. Thank you.
Sorry, I believe he's just taking a comfort break.
He's what?
He's taking a comfort break. Yes, sir.
Attorney Smith, Attorney Brooks, ready? All right, we'll bring the jurors in now. Bring them in. Please rise for the jury.
All rise for the jury.
All right, I'll ask the jurors to please remain standing. Everyone else, you may be seated.
Members of the jury, I'm going to swear you in now. So if you could please raise your right hands, and at the conclusion of the oath, if you would please say, "I will." You so solemnly swear or affirm that you will carefully consider the evidence and the law presented to you in this case, and that you will deliver a fair and true verdict as to the charges or charges against the defendant, so help you God. Thank you. Members of the jury, you can be seated. I'm going to now read the charges to you in this matter. There's 5 charges. The first is charge ID 1937947C. This states that Adam Montgomery of Manchester, New Hampshire, in the state of New Hampshire, between approximately July 1st and July 22nd, 2019, at Manchester in the county of Hillsborough aforesaid, did commit the crime of second-degree assault, in that Adam Montgomery did knowingly cause bodily injury to H.M., date of birth 6/7/2014, a child under the age of 13, by striking her in the face. Said acts being contrary to the form of the statute, in such case made and provided and against the peace and dignity of the state. The next charge in this matter is charge ID 2027112C, and this states that Adam Montgomery of Manchester in the state of New Hampshire, on or about December 7th, 2019, at Manchester in the county of Hillsborough aforesaid, did commit the crime of second-degree murder, in that Adam Montgomery did recklessly cause the death of Harmony Montgomery, date of birth 6/7/2014, a person under 13 years of age, under circumstances manifesting an extreme indifference to the value of human life, by repeatedly striking Harmony Montgomery on the head with a closed fist. Said acts being contrary to the form of the statute, in such case made and provided and against the peace and dignity of the state. The next charge is charge ID 2027113C, and this states that Adam Montgomery of Manchester in the state of New Hampshire, between approximately December 7th, 2019 and March 4th, 2020, at Manchester in the county of Hillsborough aforesaid, did commit the crime of falsifying physical evidence, in that Adam Montgomery, believing that an official proceeding, as defined in RSA 641:1, Roman numeral 2, or an investigation was pending or about to be instituted, did purposely alter, destroy, conceal, or remove the body of Harmony Montgomery with a purpose to impair its verity or availability in such proceeding or investigation. Said acts being contrary to the form of the statute, in such case made and provided and against the peace and dignity of the state. The next charge in this matter is charge ID 2027114C, and this states that Adam Montgomery of Manchester, New Hampshire, at Manchester, between December 7th, 2019 and March 4th, 2020, did commit the offense of abuse of a corpse, in that the defendant did purposely and unlawfully removed, concealed, or destroyed the corpse of Harmony Montgomery or any part thereof. And this is against the peace and dignity of the state. And then the last charge is charge ID 202-7115C. And this states that Adam Montgomery of Manchester in the state of New Hampshire between approximately December 7th, 2019 and January 4th, 2022, at Manchester in the county of Hillsborough aforesaid, did commit the crime of tampering with witnesses and informants, in that Adam Montgomery, believing that an official proceeding as defined in RSA 641:1, Roman numeral 2, or investigation was pending or about to be instituted, did purposely attempt to induce or otherwise cause Kayla Montgomery to testify or inform falsely. Said acts being contrary to the form of the statute in such case made and provided and against the peace and dignity of the state. Ladies and gentlemen of the jury, the defendant, Adam Montgomery, has been arraigned on these charges and he has pleaded not guilty, and of this he puts himself upon his country for trial, which country you are. Assistant Attorneys General Benjamin Agati and Christopher Knowles for the state have joined the issue, and you are to say by your verdict if the defendant, Adam Montgomery, is guilty of the crimes whereof he stands indicted or not guilty. Hearken to the evidence. Thank you.
Members of the jury, shortly you will hear opening statements by counsel. Before that, I'm going to give you some general instructions as to the law that applies to this case and some other matters which will give you some guidance as you consider the evidence in this case. After you have heard the evidence and you have heard closing arguments, you will hear further instructions from the court, and then you will retire to the jury deliberation room to decide your verdict. You should consider all of the instructions I give you, both now and at the end of the case as a whole, and not single out one particular instruction as stating the law. You will also have written copies of my instructions with you in the jury deliberation room. So, ladies and gentlemen, this is not a memory test. What I ask of you now is just listen carefully to the instructions that I give to you. You will have as many copies as you like in the deliberation room when it comes to decide your verdict. So you will have written copies of both the instructions that I give you now as well as the ones that I give you at the end of the case as a whole. And every juror can have one available to them. So please just listen carefully now as I give you these instructions. The function of the court and the jury. In order to reach a fair and just verdict, you must understand and follow the law as I explain it to you. For example, you have to understand the definitions of the crimes with which the defendant is charged. You have to understand how convinced one way or the other you should be before deciding your verdict. You have to understand what to consider in deciding whether to believe a particular witness. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions I am about to give you. Regardless of any opinion you may have as to what the law ought to be, the law as I explain it to you is the law you must follow in reaching your verdict. It is up to you to decide the facts. You must decide the facts solely from the evidence in this trial. You must apply the law given to you in these instructions to the facts and in this way reach a fair and just verdict. You should decide the facts without prejudice, without fear, and without sympathy. You should decide this case based solely on the evidence presented and the law as I explain it to you. The evidence in the case. In deciding this case, you should consider only the evidence in the case. The evidence consists of testimony under oath of the witnesses, exhibits which have been admitted into evidence, facts of which I take judicial notice, and stipulations of certain facts. During the trial, the lawyers may make objections. The lawyers are supposed to object when they believe that certain evidence is not admissible. If I sustain an objection or exclude any evidence, you must not guess as to what the answer or evidence would have been. If I order that a question and answer be stricken from the record, you must not consider either the question or the answer as evidence. A judge is required to be neutral, and I am in fact neutral. If during this trial or at any point during these proceedings you believe that I have expressed or suggested an opinion as to the facts in my rulings, you should ignore that belief. It is up to you alone to decide the facts. In short, you should consider only the legally admissible evidence in deciding this case, that is, the testimony of the witnesses, the exhibits, stipulations, and facts of which I took judicial notice. We talked earlier that there will be a view in this case, and I'll give you an instruction on the view later, but the view is also evidence in the case, but you'll hear an instruction on that in a little bit. The indictments are not evidence. The fact that the defendant has been arrested and indicted is not evidence of guilt. The indictments are simply a way of giving the defendant notice of the charges. The indictments are a formal way of accusing the defendant of a crime in order to bring the defendant to trial. You must not consider the indictments as evidence of guilt. Multiple indictments, one defendant. Each of the indictments against the defendant constitutes a separate offense. You must consider each indictment separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on one of the indictments should not influence your verdict with respect to the other indictments. The possible punishment the defendant may receive if you return a guilty verdict should not influence your decision. The duty of imposing sentence is solely for the judge. You should base your verdict only on the evidence and the law without considering the possible punishment. The presumption of innocence. As you were instructed during the general selection process, there is a presumption of innocence that applies and continues throughout this trial until the state convinces you, beyond a reasonable doubt, that the defendant is guilty of each and every element of the offenses with which he has been charged, and the defendant has no obligation whatsoever to prove his innocence in this matter, and that includes the right not to testify if he so chooses. You are not allowed to draw any unfavorable, adverse, or negative inference if the defendant does not take the stand in this matter. The jury's recollection controls. You will hear the lawyers discuss the facts and the law in their opening statements and closing arguments to you. These statements and arguments are not evidence. Their purpose is to help you understand the evidence and the law. If the lawyers have stated the law differently from the law as I explain it to you in these instructions, then you must follow these instructions and ignore the statements of the lawyers. If the lawyers state the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. Direct and circumstantial evidence. There are two kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as the testimony or statement of a person about what the person saw, heard, or did. Circumstantial evidence is indirect evidence, that is, proof of a chain of facts from which you could find that another fact exists, although it has not been proved directly. For example, if you look outside and see water droplets falling from the sky, that is direct evidence that it's raining. But if you look out the window at night and the ground is dry, and again the next morning and the ground is wet, that is indirect or circumstantial evidence that it rained during the night. By circumstantial evidence, I simply mean that you may infer the ultimate fact from another fact shown. You should feel free to reach reasonable conclusions from proven facts. Conversely, you may not reach conclusions based on facts that have not been proved. In the rain example, wet ground alone may support an inference that it rained during the night. But in the absence of additional evidence, it will not necessarily support inferences about how much rain fell or for how long a period of time. You should consider both kinds of evidence. You are permitted to give equal weight to both, but it is for you to decide how much weight to give any evidence, whether it be direct or circumstantial. However, to be sufficient to establish guilt beyond a reasonable doubt, circumstantial evidence must exclude all other rational conclusions. This means that if from the circumstantial evidence it is rational to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the rational conclusion consistent with innocence. In determining whether all rational conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all of the other evidence, which includes all other circumstantial evidence and direct evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. If there is a conflict between two or more witnesses who offer direct evidence concerning certain facts, you should resolve the conflict. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in direct evidence. In this situation, you, the jury, should resolve the conflict and must decide whether, based upon all of the evidence, the state has proved the defendant's guilt beyond a reasonable doubt. You should consider all of the direct and circumstantial evidence in the case, as well as any reasonable inferences you draw therefrom, in deciding whether the state has proved all of the elements of the crime beyond a reasonable doubt. The credibility of witnesses. In deciding this case, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. Use your common sense and judgment. Consider factors you use in deciding important issues in your everyday lives. For example, you may consider the following: the witness's attitude, behavior, and appearance on the stand, and the way the witness testifies. The witness's age, intelligence, and experience. The witness's opportunity and ability to see or hear the things about which the witness testifies. The accuracy of the witness's memory. Any motive of the witness not to tell the truth. Any interest that a witness has in the outcome of the case. Any bias of the witness, or friendship or animosity the witness may have for or against any of the other people in the case. The consistency or inconsistency of the witness's testimony. Whether or not what the witness says appears reasonable or unreasonable. Whether what the witness says is consistent or inconsistent with the testimony of other witnesses or with statements the witness made at another time. In deciding which witness to believe and how much of their testimony to believe, you should consider both the direct and cross-examination of the witnesses. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted. Nor are you required to accept testimony as true because some or even all of the witnesses agree with each other. You may find the testimony of one witness or of a few witnesses more persuasive than the testimony of a larger number. These principles apply to all witnesses, whether they are ordinary citizens, police officers, experts, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. The weight to be given to the evidence should be determined by the quality of the evidence, not the quantity. It is not the number of witnesses or the quantity of the evidence, but the quality of the evidence that is important. The judge decides what is admissible. Testimony, writing, objects, and other things presented during the trial are evidence only if the judge accepts them as evidence. Throughout the trial, I may rule on whether certain evidence was admissible or not admissible. These are legal decisions which do not concern you, because only the judge is permitted to decide legal questions. I may make 3 types of legal decisions with regard to the evidence. First, I may stop some information from being presented at all. You are not to imagine what that information might have been had I allowed it to be presented. Second, I may rule that some information was not admissible after it was presented to you. You are to ignore this information and not use it as evidence. Finally, I may allow some information to be entered as evidence after hearing objections by one of the lawyers. You are not to give such evidence any special importance as a result of my ruling. It is not my duty, and I do not try to determine whether the evidence is important when I make my rulings. The burden of proof and reasonable doubt. Now, I've addressed what you should not consider and what you should consider in reaching a verdict. I'm now going to discuss with you how convinced one way or the other you must be, and this is referred to as the burden of proof. Under our constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant does not have to prove his innocence. As I told you earlier, the defendant enters the courtroom as an innocent person, and you must consider him to be an innocent person until the state convinces you, beyond a reasonable doubt, that he is guilty of every element of the alleged offense. If after all of the evidence and arguments you have a reasonable doubt as to the defendant having committed any one or more elements of the offense, then you must find him not guilty. Now finally, ladies and gentlemen, a reasonable doubt is what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based upon reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based on reason as remains after consideration of all of the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proven any one or more elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proven all of the elements of the charged offense beyond a reasonable doubt, you should find the defendant guilty. With respect to the final instructions regarding the offenses, I will wait until the end of the trial and after closing arguments and discuss it with you at that time. So as I said, I will give you another set of instructions after closing arguments at the end of this case. You will have all of these instructions with you in the deliberation room when it comes time to decide your verdict. As I said to you earlier, there's a form of this instruction that I'm about to give you. We call it the communication instruction that I'll give you. I've given you some of it before, and I'll continue to give it throughout the trial. Please listen very carefully. Do not discuss the case at all, not with the other members of the jury or with anyone else, until jury deliberations start at the end of the trial after all of the evidence and final arguments have been presented. Please keep an open mind until you have heard all of the evidence in the case. During the course of trial, please take care to avoid any contact with any persons involved in the case, the lawyers, the witnesses, and the parties. So I remind you, ladies and gentlemen, as you come in and out of the courthouse, you may see the lawyers or other people involved in the case. They have been instructed that they are not to communicate with you, so they are not being rude if they don't acknowledge your presence or smile at you or say hello as you may pass them in the hallways. But you must, they are required to avoid any contact with you, and you are required to avoid any contact with them. So no contact with anyone involved in the case, please. Also, please be sure to avoid any television, radio, online, or newspaper coverage of this case. I anticipate that there will be media coverage of this case. As I indicated earlier, you know that there are cameras in the courtroom. They have been instructed that they are not to take pictures of the jurors in the case, but I expect that there will be media coverage. You are instructed that you must not read any articles or view any media coverage on television, online, or elsewhere. So avoid your local papers. Have somebody pull the international section if you want, but don't watch any media coverage of the case, okay? You are instructed to turn off any notification or banners that come through your smartphone, computers, smartwatches, or other devices, okay? Finally, do not conduct any research or investigation of your own. You must render your verdict based solely on the evidence submitted at trial. So don't look up the law. That will be given to you in the court's instructions. Don't drive by any locations. Don't look up any names. Don't look anybody up on social media. It is critically important that your verdict in this case is based exclusively on the evidence that's presented at trial. Our trial day will generally go from 9 a.m. to 4 p.m. We will also generally take a mid-morning and mid-afternoon break. I try to look at sort of natural break points in the case to determine when those breaks happen. But generally we'll have a mid-afternoon, mid-morning break, and we'll also have a lunch break. The court has asked you to put your cell phones in a box in the jury deliberation room. Please make sure they are silenced or turned off altogether. As I said to you, you will be permitted to check your phones when you are on break. However, you are not to look at any news reporting or media coverage of this case, as I have already told you. Additionally, you are not permitted to take notes of any kind, not on paper nor on your phones. The reason for this is that it is important that your recollection of the evidence is what controls. Sometimes, if notes are taken, they can be given undue weight, and it's important that when it comes time to deliberate, you are using your individual and collective memories about the evidence, and one note or one written recollection doesn't control. You should also be aware that there will be no transcript available to you when it comes time to deliberate. So although we have our excellent court monitors here and there's an audio recording, that is not available to the jurors, and there will be no transcript. So your individual and collective recollection is what will control as you go into the deliberations. Therefore, please listen carefully to the evidence as it is presented. If during the course of this trial you have any questions or problems, you become thirsty or need anything else, just get the court officer's attention, either of our court officers or my attention, so that we can assist you. If at any time during the trial you cannot hear, please raise your hand so that I can ask the witness or the lawyers to speak up. That goes as well for any monitors. If you cannot see, please do let us know. It is important that you are viewing and listening to all of the evidence as it's presented. So, ladies and gentlemen, it is now 20 of. I had indicated to you earlier that I thought we would go right into opening statements, but based on what I anticipate the length of the opening statements will be, I think that would hold your lunch off for quite a long time. So after speaking with the lawyers, I think what we're going to do is we'll take an early lunch break. So we're going to break now. Please come back at in 1 hour, so 20 to 1. And then we'll move directly into opening statements. So don't talk about the case, not with each other, not with anybody else. Don't look up any media. Don't do any independent research. And I will see you in an hour after lunch. Thank you so much, ladies and gentlemen. All rise for the jurors. You can be seated. Do we have anything preliminary, or do you want to just come back at 12:30, or what would you like to do?
Just thinking, Your Honor, with regards to the arrangements for the bus. Trying to figure out what the time is and what we can do, hopefully, with them to shift the times back. So maybe if we could approach on that.
Sure. Please be seated. Counsel, can you approach for just a minute, please?
I'm not real sure why we're going to have to wait all day for an opening statement, but I feel like we are, guys. What is up with this? I want them to start already. I bet Court TV knows what's going on. Let me go look what Court TV's saying. That's funny, Jennifer. Now I'm going to be humming it all afternoon. Thank you. I'm going to pop over to Court TV to see if they know what's going on.
From a black and red Under Armour duffel bag and placed the lifeless body of Harmony into the bag. Kayla stated at no point did either of them have any conversation about getting any type of life-saving measures for Harmony, and that Adam simply put Harmony's dead body into the bag and walked it back to the parking lot of the Colonial Village Apartments.
Okay, if you're just joining us and wondering, wait, where are those opening statements in the Montgomery case? We're wondering the same thing. There was a delay because the judge wanted to hit the lunch break early at about 11:40 Eastern, thinking, let's not start the openings. Let's wait till after lunch. They come back, and there's a 10, 15-minute bench conference, sidebar, which was very long. And at the end of that, they sort of just started to break things down. According to our team in the courtroom, the monitor that was up was rolled behind the judge's bench. A member of the victim relations team from the AG's office came in and took the family out of the courtroom. All signals are that this is a major delay, likely. We don't know why. We do have a team there. They're trying to gather information in terms of what's going on here. Let's bring in Washington, D.C., trial attorney and Supreme Court attorney Megan Whiteside. She's also the host of Mom Life and the Law, the podcast. Good to see you, Megan. You know, you never know until things actually start, whether or not they're going to start in a court of law. And here we have one of those, everybody's ready to go, but the brakes are on. Any speculation of what could be going on?
Yeah, it's a lot of hurry up and wait, right? This is what happens with jury trials sometimes, especially a criminal prosecution such as this. The judge...
All rise for the jurors, please.
All rise for the jury.
You may be seated. All right, sorry for the delay, ladies and gentlemen. One thing I think you will learn as you go through this process is sometimes things go exactly as we plan, and sometimes they do not. Right now, they are not going exactly as we had previously planned, so I apologize for the delay. And there are a lot of moving parts in a trial, so sometimes we need to switch things up. So originally, I had said that we were going to come in and do opening statements. We're going to do something a little different than that. As I said, we're going to be going on a view today. So prior to a view, the lawyers will give you what's called a preview statement to give you some information about what they want you to look at and what they anticipate that you will see on the view. We're going to do that first. So I'm going to give you an instruction regarding the view. Then the state and the defense will give you their preview statements, okay? And then we will wait for the bus to come, and when everybody's ready, we'll get on the bus and we'll go for the view. Then depending on what time it is after that and other circumstances, we'll determine whether opening statements will be this afternoon after the view or whether they'll be tomorrow, okay? So listen carefully to this instruction. Ladies and gentlemen, we are going to begin this case with a view. We will be traveling to several locations within the city of Manchester to observe certain areas you will be hearing testimony about. The purpose of the view is to make the testimony you will hear more understandable. If you have the opportunity to look at a scene, the testimony may make more sense to you. Your obligation on the view is to look as carefully as you can and to remember what you see as well as you can. You may not ask questions. You may not take any notes or measurements. You should look carefully at what the lawyers will be pointing out to you. What you see on the view is evidence in this case. Please stay as close together as possible so that you will all be viewing the scene from approximately the same perspective. If you cannot hear or see, please call that to my attention or to the attention of one of our court officers. After the view is completed, you may not revisit the scenes on your own during trial. Also, you may not engage in any discussion among yourselves or with anyone else concerning what you see at the view. As you know, you are not to talk with each other or with anyone else about the case until the end of the trial when you are conducting your deliberations. At this time, ladies and gentlemen, counsel will have the opportunity to make their preview statements to you concerning what they expect you will be seeing on the view. Yes, you may.
Thank you. Good afternoon, everyone. My name is Ben, and I represent the state on this. What we're going to do, and first of all, since it's my first opportunity to talk to you as the jury, big J as opposed to little j, let me thank you again for your time that you're going to be putting forward not only today but throughout the trial. It is very important both to society, to the government, to the citizens, and is very, very much appreciated. The first part of your job, for the most part, is going to be taking place in this room. The vast majority of it dealing with the witnesses and the exhibits that you see. But as you just heard from Judge Messer, another part is going to be the view. This is evidence, what you're going to see today. It is going to be work on the view. You're going to have to walk around in 2 different locations, and the rest of them will require you to look out the windows of a bus to be able to take into account the neighborhoods that you were in. And I'm going to explain every place that we're going to go in just a moment, and then defense counsel will also have that same opportunity. Together, we are going to see where this happened. You're going to get to see the same places, the same locations in person that you are later on going to see and hear evidence at trial. And you've already heard, again, Judge Messer's instruction. You should consider today's view to be like evidence. In a few minutes, we are going to get on a bus, maybe about an hour, and we're going to see a couple different locations in Manchester. In some ways, it's going to be the beginning of a journey that you will likely never forget. And this is also the last journey that Harmony Montgomery took while she was alive, and where her body went afterwards. It's a journey that's into the actions of the defendant on that day and the days forward. And we're We're going to drive by places where Harmony was first assaulted, or she was later killed, or she was later consolidated and crushed. And then finally, different other locations of where the defendant had her in the safe. What you are going to see today is part of the evidence. Some of the locations that we're going to drive by, we are just going to pass by in the bus for a minute, and the bus is going to pull over to the side of the road. So you have an opportunity to look at that location, take in the surroundings. And on 2 of the locations, we will physically get out. One will be a parking lot, and the other one will be an intersection. We will not be going into any residences. Later on, you're going to hear testimony about different homes. We may be driving by an apartment complex today, but we will not be going inside in the actual rooms where Harmony was, or where Harmony later was kept. So we will be outside for the 2 times that we get out of the bus. So before we do that, I want to kind of start at the beginning. The first place that we're going to go to, and this is, Ms. Johnson, forget my art skills, high school. We're going to start at the courthouse. And the first place that we're going to go to is we're going to go down past Elm Street. Definitely not to scale. We're going to come across Merrimack, and we're going to go up here on Market Street. And at that point, we're going to pull the bus over to the side of the road, and you're going to be able to look out, and I would say look out the right-hand side of the bus to the area of 20 Market Street. That's the location of the methadone clinic, where the defendant took Harmony that morning with the rest of the family inside a 2010 gray Chrysler Sebring. When you're there, I want you to be able to take into account just the outside of the building and also look at the neighborhood. I want you to see the number of other businesses that are nearby, the number of other cars that are nearby, the number of the amount of foot traffic that may be there while we're there. You're going to hear in opening arguments that it was at that first location outside the methadone clinic that the defendant came out from getting his medication, got into the car, and understood that Harmony had had an accident, saying words to the effect of, "Really, Harmony, again?"
Objection, Your Honor.
Approach.
That bag is huge. What's in it?
Ladies and gentlemen, that objection is neither sustained or withheld. The state will clarify. Go ahead.
When we're at that location, later on, you're going to hear testimony that at that location, when Adam came out from getting his medication, you hear testimony that he sensed and smelled that Harmony had with a bathroom accident, and that's where the assaults began of striking. That's why it's important for you to look around, to see what else and who else is there, and to know what that area looks like. From there, we're going to then come back onto Elm Street. Probably do a loop around. Go north on Elm. Then we're going to go up to Webster Street at the top of Elm. And that's right over where you get past where you would go on the bridge, the big Brady Sullivan Tower there. We're going to take Webster Street out. And here, we're going to go out on Daniel Webster Highway. And there's a Burger King. When we get to the Burger King, again, we won't be getting out of the bus, but we're staying inside, and you'll have a chance to look at that parking lot. What the state is asking you to do is to pay close attention during that drive. How many stoplights roughly are we going through? What are the road conditions like? How long does it take to get there? You're going to hear testimony later on about that same drive. You're going to hear testimony how during that drive the defendant's assaults continued. And he continued to hit Harmony as they stopped at red lights, as they stopped at stop signs. That's why you need to pay close attention during that drive. And we're going to go out to that location. After we've had a minute or two to sit in the bus there at Burger King, and you've had a chance to see the traffic flow, see what cars are like. At that time, we're then going to turn around. We're going to come back down Webster, continue north on Elm, and then we're going to cut over to an area on West River Drive, approximately 59 West River Drive. And there, we're going to make our first stop where we get out of the buses. 59 West River Drive is one of the street locations for Colonial Village Apartments. It's right up on the, you can see poorly drawn river. It's right on the backside there. We're going to be pulling in between those buildings and going to a very large back parking lot that's behind there. This is where you have testimony that the defendant lived in his car after they had been evicted from their Guilford Street home, and where the defendant kept Harmony and the rest of his family after they left Burger King, after he continued to hit her, and drove back there to eat his food while Harmony was mowing. We're going to hear testimony that that's where he used his drugs while Harmony died. When you're there, I'm asking you to notice the number of apartment buildings that are nearby. Look at the number of cars that are in the parking lot, how big that parking lot is. I'm also going to ask you to take notice in that back parking lot area, look towards the tree line. Look at the very back row, closest to the river, where different cars can park. Notice all of that while you're there. It's going to be more than 1 or 2 minutes. So you can get out, you can certainly walk around, take your time to really look in that area and look at the different details that are there. Also look up at the side of the building. I'd like you to know whether or not you see lights on the side of the building that illuminate that parking lot, whether there are street lights that illuminate that parking lot. So do that while you're there. Once we're done, we'll get back on the bus and we're going to drive back towards the city, back on West River Road, back to Elm, and then south to the intersection with Webster. The buses are going to pull over on the side here, and we're going to get back out yet again. You'll hear testimony that it was here that the defendant's Gray Sebring died, in the intersection. That it was here that where, with his family, the car stopped working, and that it was here, just before he needed to get a tow, you'll hear how he went to the back seat and found that Harmony was no longer alive. I want you to look very closely around that intersection. Look at the traffic going through that intersection. The number of people that were available at that intersection. We're also going to hear the testimony that at that time, when he realized that she was dead, that when you look at the different businesses around, I want you to remember that when later on you're hearing testimony how his actions was to take Harmony and to stuff her in a duffel bag. You'll also hear later a trial from a tow truck driver, and you'll hear about a gas station on the corner. So while we're in the intersection, and we're not going to stand in the middle of the intersection, obviously we're going to be standing on the sidewalk, but while you're there and you can move around, take note of how far away that gas station is and the short distance that the tow truck driver had to bring the car. And once we've spent enough time considering all of these, then we're going to be going to another address. You're going to hear a testimony about a lot of different addresses where the defendant brought Harmony's body afterwards. We're not going to be going to the first two addresses, that one that involves, you'll hear involves a deck, another one that involves a red cooler. We're not going to be here, we're not going to be driving by one on Lake Avenue as well, that you'll hear testimony later on about where he stored Harmony in the ceiling. Where we're going to go is 644 Union Street. So from this intersection, we'll come back onto the buses, onto Webster, come over to Union Street, and head south. And the intersection of 644 Union Street is right at the intersection of Union and Orange. So Orange is the cross street. You're going to see two buildings. We're going to be stopping right outside here, 644 Main. Testimony that you will hear later on involves also a parking lot that's general in the back. But here, we're not going to be getting off the buses. You're not going to have to go inside. We're going to ask you to, again, look out the right-hand side of the buses and the size of the building. While you're there, we're going to ask you to please take a look at the number of apartments that are there, the number of neighbors that the defendant would have had based upon looking at those apartments. Look at the traffic, look at the lighting, look at the neighborhood. Later on, you're going to hear more testimony about that apartment and what took place in that apartment. Again, we will not be getting out of the buses. You do not have to go in that apartment. When we're done at Union Street, the buses will pull away. We'll come down to Bridge, back onto Elm, back south to Merrimack, and then back to the courthouse. I'm going to ask you to look at one last thing on this drive. As we come back to the intersection of Merrimack Street and Elm, roughly here compared to how I'm pointing right now, down at that intersection, right across the street from each other, there's the Thirsty Moose Tap House, which is right on Merrimack. Right across the street from that is a Chase Bank right now. When we drive back down Elm, and then we take that left-hand turn to come up Merrimack Street to come back to the courthouse, I'm going to ask you to look out the right-hand bus of the window. We're not going to be slowing down there. It's Elm Street, a little too busy. But I do want you to look outside that Chase Bank. In the winter of 2020, you will hear testimony that that was not a bank, that that was the Portland Pie Company, pizza shop, that that was where the defendant worked. And you're going to also hear testimony that that was where, on one occasion, he ordered his wife to bring a CMC bag containing Harmony's body and stored it inside a freezer, seen by other witnesses. So when you hear those witnesses and they talk about Portland Pie Company, we're going to be driving by that location. Again, it's a bank now. It's not a pizza place anymore. But understand where that location is to be better understand the testimony that you're going to hear throughout the rest of this. And let me stress again, what you see on this view is going to be evidence. The locations we're stopping at: the Habit Methadone Clinic, the Burger King up on Daniel Webster Highway, coming back to Colonial Village where we'll get out, to the intersection of Elm and Webster where we will also get out, the drive by 644 Union Street, and then back to Elm and the drive by what was Portland Pie Company before we come back to the courthouse. This will be your only opportunity, as you heard from the court, to look at these places in person until the end of this trial. So take your time. If you need more time, please let the court staff know, and we will stay longer in the parking lot. We will stay longer at the intersection. We have great deputies and bailiffs who will allow you to be able to explore the space in a safe manner, so that you're not going to feel like you've got traffic right on top of you or anything like that. So do please take your time. But when you listen to the testimony from the different witnesses, these are 5 of the key locations that you're going to hear. So it's important that you know what they look like in person before you hear that testimony. Based upon that, again, after you hear this and after you see all of the evidence of this case, we'll ask you to return a verdict that is just. But I would also ask you if you would please do also pay close attention to defense counsel's comments about the view, because again, the more observations that you can make on today's view, the better it will be for you to understand the testimony you see later on. And it's a one-only shot. Okay? Thank you very much. Thank you.
Good afternoon. This is where the trial really begins for you, and you literally step into it. You step onto the bus, you go to places. These places are exhibits of your mind. These places in your mind you apply to everything else that you hear, see, and consider in this case. The state said that this was the last journey that Harmony made. This is where the dispute starts. This is not the journey that Harmony made, but this will be the journey that we make today. And when we leave here and we go to Merrimack Street, that's a clinic. And it is a clinic that you'll hear testimony that Adam and Kayla frequented all the time, or quite a bit. And that when you're there, I want you to look. We can't recreate what was happening on particular days or particular weeks, who might have been coming and going at what time. So you actually can only look around and see the exposure. What is the parking there? What can you see? What is exposed? What is hidden? And then apply the evidence that you hear about events that may have occurred there, and consider, could this have happened? Put your mind to the testimony and apply it. This is what I saw, this is what I remember, this is what the witness is saying. It is your evidence, but it's evidence in the case. Then you'll go from the clinic to Burger King. And at Burger King, that's really very, very important to look at that entire layout. Again, we can't recreate the amount of traffic that was on a particular day or a week. We can't recreate any of that stuff. But you look at the parking. I want you specifically to look at how that drive-through works out when you make the order and then you pay the cashier and then you get your food. Take that into consideration. Take the time to think about a route through the drive-through. What is exposed? What is hidden? Who can see what from what angle? Think about the cashier. Think about all of the stuff around the drive-through. And actually, when you're there and stop, think about that from the time somebody pulls into the parking area. And again, you will be applying that to somebody else's testimony, and then you'll be thinking and applying that. Does this work? Does this not work? What's going on here? It is your evidence. From there, you heard that we're going to Colonial Village, and that is a place that you're getting out. So you will take the time. Traffic is going to be different from testimony that you hear about, but you want to look. What is exposed? What is hidden? From particular places, looking at the building, what can you see? What can't you see? We're going to direct you to particular places and areas and say, take a look and consider from this perspective something that pictures can never quite do. Then you got to hold it in your mind and again apply it to testimony as it comes in. This is an exhibit throughout the trial, not just for this afternoon. From the Colonial, you will go to Elm and Webster, which is a place that you're going to get out, and that is really critical on traffic because, again, it can't be recreated, but there is going to be testimony about traffic, about reaction to traffic. There's a car that's broken down there, and about what people did about the car, about what traffic was like because the car was broken down. And you want to, again, look, what's exposed, what is hidden, and apply your exhibit in your head to the testimony that comes here at trial. Then Fit Shelter is the next place, And you're going to hear about information that happened inside fit shelter. So you won't have that sort of same perspective of what's exposed and what's not exposed, because you won't actually see that part. And there's testimony about fit shelter that is very disturbing, but you still need to go there so that you put it in place about the type of place that it is. And
Objection? I'm sorry, I think there's an objection. Essentially withdrawn.
messing up my words, Union Avenue. Sorry. You will not be going into Union Avenue, but some very disturbing things occurred at Union Avenue, so you want to hold this into your head. Think about the building, think about the location. Remember Union Avenue, even though you can't go into it, and I think you'll be very happy that you don't go into it. All of this is an exhibit inside of your head, and keep the names a little bit better than I did. I'm so sorry about that. But the location is the same, and this is the journey that we are taking. And at the end from Union Avenue, you're going to come back here, and as they say, pass by the corner at Merrimack and Elm. Keep that in mind. I also want you to keep in mind the distance from the two. Distance in this case is a little bit less important, but still something to keep in mind as a person testifies about traveling from place to place, about how long does it take, the traffic lights, what is a delay. And I did forget, at each of those traffic lights, I want you to look around again, just as you're going through the traffic lights. What's exposed? What is hidden? You're going to be on streets. Assume that everything on the street is exposed. Look around on the sidewalks and the areas around it as well. It's a difficult thing. Again, you're not taking notes. And you're going to have to remember this as you apply it to all of the testimony in this case. All of these locations are important, not necessarily for the reasons that the state said. There is a dispute going on here, but there is no dispute that all these locations are very, very important. And we can only ask you to pay attention as best you can. When we get there, we'll just remind you of perspective and specific areas to look at. I believe that we'll be going behind you to make sure that the bus stops long enough for you to absorb all of the areas before you go to the next one, until you step out and actually walk around, starting at Colonial Village. Thank you.
All right, ladies and gentlemen, that concludes the preview statements. So what I'm going to do now is I'm going to send you back into the jury deliberation room. This is a good time to use the restroom, have a drink of water. I think we've got a little bit of time before the bus arrives. We will let you know when the bus arrives, and you'll be escorted by the court officers. I will be on the bus with you, as well as some of the court staff. The lawyers will be going separately. So just be patient. As soon as the bus is ready for us and all of our business here is concluded, we will go ahead and get on the bus and begin the view. All right? The reminder about not talking about the case with each other or with anyone else or doing any independent research, make sure you don't do that. Okay? All rise for the jurors, please. counsel?
Why are they bringing that big TV in? So we have to wait here for hours again. Do you think they'll come back today? I'm not so sure they will.
You admit to each and every element of the offense of falsifying physical evidence and abuse of corpse. Is that
Yes.
okay? And did you speak with your lawyers in detail about that?
Yes, I did.
And have you reviewed the opening statement in which they will tell that to the jurors?
Yes, I did.
And do you wish for them to acknowledge your guilt on both of those charges, falsifying physical evidence and abuse of corpse?
Yes.
And do you understand that it would be the state's obligation to prove each and every element of those offenses beyond a reasonable doubt before the jury could find you guilty? Do you understand that?
Yes.
And that by agreeing to allow them to acknowledge this in opening statements, the jurors can find you guilty of those two offenses, relying
Yes.
on that information. Do you understand that?
Yes.
Okay, and that is what you wish to do?
Yes, ma'am.
Okay, do you have any further question about that?
No, I do not.
All right. Anything further that the state requests?
Where is he? Is he not in the courtroom?
The knowing, intelligent, voluntary waiver of essentially proof of his facts and proceeding this way, which
I'm lost.
Okay. So anything you want to add, Attorney Smith?
Not on that issue.
Okay. So, Mr. Montgomery, having heard from you that you've discussed this with your lawyers, that you've reviewed the opening statements, the draft of the opening statement, that you acknowledge that you understand that the burden of proof is on the state to prove each of those offenses beyond a reasonable doubt, and that it understanding that it is your desire for them to proceed with that strategy, the court does find that this is a knowing, intelligent, and voluntary waiver of your rights and will allow them to proceed on that basis. Okay?
Oh, yep.
Okay. So while I have you, today you did refuse transport, so I want to talk to you about tomorrow. As we discussed with you this morning, you can't change your mind midway through the day, but you can inform the court if you wish to come tomorrow. And what I would like to do, and each day thereafter. So you can come and we will send a transport for you. That is your absolute right. But as I explained to you this morning, it's also your right to waive your presence and for us to proceed in your absence. So what I'm going to do is I'm going to instruct the Sheriff's Office and the Department of Corrections that someone will ask you tomorrow morning, do you wish to come to court today? We will have transport available to you if you want to come, but I am not inclined to send a car up there to pick you up only to have you refuse. So do you understand that?
Yes, ma'am.
Okay, do you have any concern about that procedure?
No, I do not.
Okay. So it is our intention to have someone ask you tomorrow morning whether or not you wish to come. And whenever they come to ask you that question, they're going to need an answer from you so that we have sufficient time to make sure that we get you down here in order for us to start the trial in a timely manner. Do you understand that?
Yes, ma'am.
Okay. And I believe your counsel will be speaking to you later, at some point later today?
Not today.
Oh, not today.
We can't.
Okay.
24-hour notice.
Okay. So that's going to be the procedure for tomorrow morning and each day thereafter of this trial, unless and until the court makes a different order on that. Do you understand that?
Yes, ma'am.
Okay. Is there anything further from the state while Mr. Montgomery is present?
no, Your Honor.
Okay. Anything further from the defense?
No, Your Honor.
All right. Mr. Montgomery, you're free to go now. I appreciate that that you are speaking with us when we need to speak with you, because we are keeping the jurors waiting when we do this.
Okay.
All right.
Thank you.
All right. You're all set. All right. Counsel, we will wait to hear when the bus is here. As soon as the bus is here, I guess I'll just have you all notified. Yes. Yes, I know. Oh, the bus is not here, right? When we thank you, Peter. When the bus is here, let us know so that we can gather everybody up and make sure everybody's in their respective vehicles at the right time. So we'll have somebody, probably the court officer will check in with you. I'll get on the bus with the court staff and the jurors when we get the go-ahead from everybody. Okay? All right, very good. Let me know if you need me before then. Attorney Gotti?
Yes, ma'am.
Counsel?
I think that they might be done for the day. So thank you everybody for joining. We'll be back in the morning. Um, of course he's going to try and blame Kayla. But yeah, I agree, Jennifer. I agree.
All right, good afternoon, council's interested parties. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. in 22 SC 1835572. All right, Mr. Stillwell and Mr. Botts and Mr. Sharp, good afternoon, gentlemen. Good afternoon. All right, Mr. Williams, Mr. Steele, Mr. Adams, and Ms. Renard, good afternoon. All right, Mr. Kendrick and Mr. Weinstein, good afternoon. All right, Mr. Huey and Mr. Matthews Jr. and Sr., good afternoon. All right, Mr. Nichols, Ms. Westmoreland, Mr. Harvey, is Mr. Garner behind that? No, Mr. Garner. Okay, all right, good afternoon. All right, Mr. Ryan and Mr. Williams, good afternoon. All right, Ms. Hilton, Ms. Love, Mr. Atkins, and Messrs. Smith and Brown, good afternoon. All right. All right, so I name all our jurors here?
Yes, sir. That's correct.
Okay. All right, is Detective Belknap in he's there? Okay, all right. Anything I need to take up before I call him? I'm just being kind. I'm really not interested in taking up anything, but what is it, Mr. Sharp, since you were first?
Your Honor, the state sent all defense counsel a video, and my understanding is it's marked 60W. It's not been admitted into evidence. And my understanding is they plan to play this video through Investigator Belknap. The defense, Mr. Stillwell, as well as all the other defendants, do have specific objections to the introduction and publishing of this video. And I want to voice those concerns and make those objections now while the jury's still not with us.
What does 60W purport to show, Mr. Sharp? And then,
Come up.
yes. That's my first question. And then the second question is, what specific objections do you have as to it?
Well, Your Honor, I am not certain as to the reasons why the state seeks to introduce it. I will say that this video...
Answer my first question.
What's the
video purport to show?
The video, I believe, shows a number of individuals. I'd put around 20 that are hanging out in what appears to be a parking lot. I believe that's outside apartments in the Cleveland Avenue corridor.
Okay, how long is the video?
The video is approximately 15 minutes.
No, it's about
7 minutes.
Okay, all right, 7 minutes. And then what's anything else about this video on these alleged 20 individuals in this parking lot?
So there's definitely, I would say, a general main narrator who's a gentleman that is not one of the accused. I think I may know who he is, but I wouldn't want to say that with certainty. He's kind of narrating, this is what we're doing, this is what's going on, and just kind of, I would say, puffing for the camera. There are other individuals smoking marijuana, leaning on cars and whatnot. There's a young lady who's saying that she's the only lady that's present, and she's speaking to the camera. Mr. Williams, I believe, makes an appearance on the camera for a short time. I don't believe any of the other charged individuals appear on the video. There are other people who I know the state has alleged are co-conspirators or YSL associates that appear on the video. They're not the ones that are talking. Generally, I believe that an individual by the name of Quindarius Zachary at one point has a firearm in his possession. There are individuals with firearms, just to be candid with the court. So it's marijuana, it's firearms, it's cussing, and bragging and the sort of thing. This is how we do it in Cleveland Avenue. You know, this is our neighborhood type thing. There are several reasons why I do not believe that this should be admissible, Your Honor.
Okay, what are your reasons for the objection?
Okay, well, first of all, just generally, I think that there's a lack of relevance towards issues that this case is about. There's certainly bad character evidence. There's certainly people in possession of firearms. There's certainly people using bad language. There's certainly people smoking marijuana. Those are all bad character that would be prohibited generally under 404A. Additionally, Your Honor, to the extent I believe in full candor, that there's what the state is going to allege some sort of gang signs, and also a brief mention about sex, money, murder, or SMM by Mr. Williams. I believe that those aspects we've seen through Detective Belknap, we've seen Mr. Williams' tweets, we've seen multiple videos, one outside a house in the Cleveland Avenue area. That was the one with the young child. We've seen two videos, I believe, of Mr. Stevens riding around in a car, rapping along with rap lyrics, saying what's alleged to be gang jargon. We've seen another video in a parking lot area with people sitting on a car. We've seen another video with Bloody J pre-video shoot where Mr. Williams, Mr. Stevens, and other individuals are saying many of these same things. Sex, money, murder, blood stuff, firearms. We've seen the tweets to the Young Thug account, and we've also seen Mr. Eppinger's Facebook page. I think the state has presented evidence that they're going to argue links some of these individuals to gangs. At this point, playing another video of people with possession of firearms and smoking marijuana and hanging out and saying things that typically you would not want a defendant to say in front of a jury, at this point is the probative value of any issue in this case is scant. It's not relevant. It's extremely cumulative at this point. We're not in this. Let me be clear, Your Honor. I'm not saying that this is the court's fault, but I'm saying in playing additional videos, it's not. It's cutting back on judicial efficiency, and it's cumulative at this point. So we believe that under the 403 balancing test, the relevance and the probative value is outweighed by the danger of unfair prejudice, substantially outweighed. Also, Your Honor, there is hearsay on this video. As I said, this narrator who has not been identified, has certainly not been named in this indictment, is just going on and giving a narration. He's not on a witness list to my knowledge. He's not testifying in court. It's hearsay, it's confrontation clause. There's been no judicial finding whatsoever that these statements on this video would qualify under statements by a co-conspirator, 801 D2E. So the state has not laid the foundation for the admission of any of these out-of-court statements. So, Your Honor, we just don't see the relevance, and we would ask that for those reasons, the state not be allowed to play the video. Should Your Honor feel that it's appropriate to play an additional video that shows the same sorts of things we've already seen through the other videos, we would ask that the state, that this video be redacted to limit the publishing the video to the salient points to actually issues in this case, as opposed to just playing a video of a bunch of young people in a parking lot smoking marijuana and cussing.
Okay. All right. Thank you, sir. Madam, Ms. Hilton.
Thank you, Your Honor. Your Honor, with this video, and if the court wants to see the video, we have it ready to be played. This is a 7-minute video that we received from Investigator Belknap, and the state intentionally did not put the video in during our initial direct examination of Investigator Belknap. However, we believe this video has become relevant given the cross-examination that has occurred at this point of Investigator Belknap. Specifically yesterday, Mr. Steele in his line of questioning to Investigator Belknap regarding the tweets, as well as even State's Exhibit 55W, there was this inference again that Mr. Williams is only doing this for promotion, to promote his music career, to promote that he's not a real gangster, but that he is a studio gangster and is promoting this lifestyle, so it's not really accurate. This video, Your Honor, is not a music video, which is a little different from State's Exhibit 54W. This is a video, I believe from 2012, in which Mr. Williams, as well as Trontavia Stevens, as well as Walter Murphy, who are all co-conspirators in this case, in addition to some witnesses we believe will be coming up in momentarily, Quindarius Zachary, are all in this video. They are in an apartment complex in the Cleveland Avenue area. A number of individuals are wearing red or have red bandanas, and Mr. Williams specifically, I believe Mr. Murphy and Mr. Stevens all are throwing up sex, money, murder symbols, the symbol for Pistol Pete. Mr. Williams himself actually says that he is a member of SMM, which would, again, going down the line of questioning that happened yesterday, would refute, we believe, is evidence refuting this notion that Mr. Williams is a studio gangster. And the state's position is that Mr. Williams, along with other members of YSL, are real gangsters. They're actual gangsters. Nothing studio about them. And so we believe that this video is relevant to to that particular portion. Mr. Shaw.
Assuming it's relevant, okay, I take your threshold issues to relevancy. What about the issues of the narrator, it being hearsay, the 403, and potentially confrontation clause issues?
Your Honor, because this is, a party opponent admission, Your Honor.
By whom?
Mr. Williams.
Okay, what about you got Mr. Williams, you got Mr. Stevens, you have Mr. you have Quindarius Zachary, and then you have three of them.
Yeah.
And four of them. I think Williams, Murphy, Stevens, and Zachary, right?
Yes. And
okay, as to those, what about the other speakers?
So what we would argue, Your Honor, I'm going to direct the court to United States v. Perry, and I'll have to get the site for you. It may be 14 4th, 1253.
I'm sorry, what is it?
It's going to be United States v. Perry, 14 F 4th, 1253, which is an 11th Circuit 2021 case. And this is regarding a telephone conversation. However, I think we can be comparable to this video. And in that case, it says it held that while the defense assertions during the recorded telephone conversations were admissible under 801 D2A, which is a party opponent admission, those made by others during the same conversation were admissible to show their effect on the defendant. Without hearing other speakers' side of the conversation, defendant's statements would have been rendered meaningless. It also says the inclusion of a non-party statement was necessary for the jury to fully understand the defendant's statements, Your Honor. So we believe in looking at the entire video, it puts into context what Mr. Williams is doing in the video, what Mr. Murphy, what Mr. Stevens are all doing within the course of that video, Your Honor. So we believe that the entire video should be able to come in.
I need to look at it seems like most of the conversations in Perry were by the co-conspirators themselves, and why not share it?
And let me say, unknown speaker, Investigator Belknap may know who the speaker is.
I'm sorry?
Investigator Belknap may know who the speaker of the video.
Do you know who it is? Does he know who it is? Has he seen the video?
He's seen the video. He's the one who provided it to us, and he's had it as he provided the video to us. And I don't know if I said an unknown speaker. I just said the non-party speaker was admissible.
Well, in Perry, unlike what you have in our case, Perry involves co-conspirators. I mean, they're definitely having conversations between them amongst themselves. So that a little different than what you have in this video. You've got you've got 4 people that are involved in your case. You've got several others that are not.
There are several others who are not, but there are several other. All of the individuals we believe were part of Rock Crew at the time, and as Rock Crew was the early iteration.
Even you know they are.
From the video, they claim that. This is the whole video when each of these members claim affiliation with Rock Crew, which is the earliest iteration of YSL back in 2012. And so we believe in the general conspiracy of the gang of Rock Crew that they would all be co-conspirators because each of them claims affiliation with Rock Crew, specifically in this video.
Okay. And how are you saying their statements are admissible? The people that aren't there, that are not charged in this indictment?
Because they would be co-conspirators of the larger general conspiracy of the criminal street gang of Rock Crew. And so that would come in under the co-conspirator exception to the hearsay rule. And I know that Mr. Sharp mentioned this is confrontation clause.
If it's conspiracy, it doesn't.
Yeah, and none of this is confrontation because none of this is testimonial to police or law enforcement. Only if it was testimonial would it be.
All right, Mr. Sharp, anything else?
Yes, Your Honor. First of all, factually, I would push back on the state's assertion that all of these people are Rock Crew associates or express so on the video. I think that's very much of an overstatement and a generalization. I don't believe that every person that speaks does that. Second, we talked about admissions by a party opponent, and we put Mr. Williams in that bucket, and I understand that. We also put Quindarius Zachary. He's not a party opponent. We put Trontavious Stevens, although he was indicted, he is not a party opponent at this time. And we put another individual as well as a party opponent, and Walter Murphy, and he's not a party opponent right now. So those statements by those individuals would not be admissible.
They're co-conspirator statements.
Well, okay, but that's a different. I was dealing with the party opponent.
I'm looking at that. So
okay, co-conspirator. Well, a few things. You can be a gang member and not be part of a conspiracy.
That's a jury question.
Well, Your Honor, you're the gatekeeper, so it's a judicial question first before the jury considers it.
Okay.
And there's no indication. For it to be a statement by a co-conspirator, it needs to be in furtherance of the conspiracy. There's nothing that is said that could be reasonably.
Isn't that the jury's determination to determine whether or not that is whether or not one, a conspiracy exists, and two, whether or not it was made in furtherance of the conspiracy based on the factual predicate that the state has the burden of proving?
No, that's not a jury question, Your Honor. That's like saying
or the weight of the evidence.
Well, I agree with the weight,
credibility of the evidence, whether or not. But
I agree with all that. But that's like saying, isn't it a jury question to determine if evidence is relevant? No, it's
No, it's mine.
Yeah, it's yours, and 801D2E is yours too. You have to make that finding based on specific facts about an individual statement to make it admissible. Again, they're the proponent. They're seeking to introduce things through exception to our general rules of evidence, and they need to make a showing, and they're simply not making it. Additionally, Your Honor, this Perry case, I just want Your Honor to understand, as someone, I've watched the video, I know the state has, I suppose you haven't yet, Your Honor. This is not a situation that's at all akin to two individuals talking on a phone, and you need to understand, you need to know what's being said on the other end of the phone call to understand what the party opponent is saying on their end. There's no need for context here. When the state is saying that someone's talking and someone else is talking, we're talking about a camera that's panning to different people. There's no indication from what I saw that this gentleman who's being the general narrator, at least from what I saw, there's no indication that Mr. Williams even heard what the narrator's saying when he says what he said. So it's not someone says something and Mr. Williams says something and we need to know what they said to understand what Mr. Williams is saying. They're completely separate conversations that just happen to be going on within this group of about 20 people in this parking lot on a random day, probably 10, 15 years ago. And I also don't know how the state knows this from 2012. That's unclear to me as well. But, Your Honor, there's no context needed. It's completely distinguishable from Perry. These are not statements in furtherance of a conspiracy, and these are not admissions by a party opponent.
All right. Ms. Hilton, anything else?
No.
Okay, can I see...
And Your Honor, also, for the record, we just received, my understanding, we just received this yesterday. That's the first time I saw it, or yesterday or this morning. Okay, my colleagues are saying that we received it last week, and so that's also an issue, the late disclosure.
All right. Madam, when was it disclosed?
Yes. Investigator Belknap disclosed it to us last Wednesday, and I think I was in court when I received it. As soon as I saw it on Thursday morning, before I even viewed it, we sent it, and Mr. Adkins sent it on behalf of the state. So we were provided to, I think, probably around lunchtime on Wednesday the 31st. I didn't see it. We were in court. Looking at the time of the email where Investigator Belknap sent it, it was probably around the 12:45 hour. I did not look at my email until that next morning. When I received it, we immediately uploaded it to Dropbox and turned it over to defense counsel, which was last Thursday at about 9:45 in the morning.
All right. Judge, Investigator Belknap's their expert witness. They've been preparing this case with Investigator Belknap. I don't think that just because the lawyers haven't received it by a certain date, that's an excuse to hand over evidence that they intend to introduce to the defense counsel at the last minute. I don't believe that is an argument that can stand.
All right, thank you, sir. Sergeant Ingram, can you tell our jurors to be at ease for a little bit, please? Just tell them to be at ease, continue to be at ease. We're still working. Do you have State's whiskey, I should say 60 whiskey, queued up to the 7 minutes you want, that you're going to propose to show to the jury?
Yes, Your Honor.
All right. Can I see it?
Yes.
My whole crew got blood. We just had to be cool, veteran, man. Anybody can play with them on Trey, they did. You know what I'm saying? It's a real rock crew movement, man. I got them pounds in on Trey.
What time? Oh, you started. All right. I'm going to answer my own question. You started at 000?
Yes, Your Honor. Started at 000.
You can continue at this point.
Hey man, nigga reading up or nothing.
Look at my thing. What's up, you little niggas, man? First later, I wrote 5, man. These bitches ain't my equal. You
We working too. We working. We working on the block. Hey man, what most of y'all niggas ran up with, man. My little girl got it on right now, man. Trey, man. She got a car and she ain't even walking yet, and that's on Trey. Hey, too bad. Hey, Rock, come chill, man. One on big. One on good. The first one good. What the hell about script up? Hey, that boy, second one, I got it. Plenty blacks. Hey, look. Man, what? They gotta get out. I really don't give a fuck about bitch. Yeah, ho. Yeah, ho. Plant 2 guns up, make a salute. You understand me? Yeah, ho. Fuck to the money game, bitch. Okay. I do that bloody trouble breaking that sex, money, murder, man. Get beat up, shit tatted on me, man. Know what I'm saying? Pee up or get beat up, man. Yeah, ho. Fuck you trouble, sex, money, murder, man. Cream, cash, rule, everything. When the bitch get due, ho. Know what I'm saying? Good weed. I ain't fucked up, nigga. I looked up. How many blunts we got a rotation though, man? You understand me? You be Smokey. About 10 of them, about 12. Different little trader, man. Y'all niggas. No, mom. Hey, man. At this point in time, we all switch, so everybody just switch. Y'all got to switch to the right. To your right. We had to switch. To your right. We had to switch. Don't do that. Everybody got a dope. Big control. Rotation. Y'all pay that shit to John. Right? Pay that shit to Sue. You heard he just said, they ain't passing the game. He say give him an ounce roll up. Yeah. Hey man. He say give him an ounce. He say give him an ounce. We got our apartments on control. Go to the car and get 3-4 ounces. We got our apartments on control. Matter of fact, go to the car and get a pound of wood. In a minute. Yikes. He talking about in a minute. And I'm riding with the chopstick. Hey, you talking about? I'm gonna show y'all what I'm riding in. Straight up. Y'all see big girl in the shrimp fried rice? Shrimp fried rice a little bit.
With and fruit punch. Man, I'm the only bitch out here in this shit, though. That's serious shit. Hello.
And yeah, that big cool Valerie, man. So anybody play with them? Ooh. 1426, man. Louis V, everything. Louis V, true. And Gucci. They have my family kicking, man. True religion, everything, man. They have my family kicking, man. That big Val, man. Little brother and Louis, he said he wants some red bottom tomorrow. I told him no problem, I got him. You know what I'm saying? I don't do my own car. You see it, man. I own all them cars. Anybody who knows somebody who ain't smoking right now, man, tell them come on, please. He can give me shit right now. I'm talking to Maybach right now. I got weed. I'm talking to Maybach right now. I'm talking to Maybach, man. We got control on our property. You know what I'm saying, man? We got cameras and shit out here, man. So anybody think they coming through, think they catching them, man. We ain't never slipping, man. We got niggas on walking, talking, man. You know what I'm saying? We got the can lady working. You know what I'm saying, man? Everybody busting for trouble, man. You know what I'm saying? They're my blood brother, you know what I'm saying? Bees up, pee up and get beat up. Oh, yeah. You know what I'm saying? But my boy DKJ got out, and he got it on him. And he got the screen up on him. You know what I'm saying? He just got out yesterday. He's my other blood brother, man. You know what I'm saying? Nah, we kick. We kick shit blue. This is everyday thing. Oh shit! Check out the trucks. This nigga just start playing my game a little bit. I got ashes on my truck. You know what I'm saying? Half of these niggas ain't got nothing on them right now, man. They been smoked out. You know what I'm saying? These niggas out here every day, man, hustling, man. You know what I'm saying? Slow. What you got on you right now, man? They been smoked out, right? Thugger. It's not SWM, it's nothing, man. It's nothing. Rock family for life. It been smoked out, hey. If it's a 50 in my bankroll, nigga, my mama a bitch. Hey, you heard that, nigga. It been smoked out. Big Val, like she ain't edged over them. What they thought?
Break one iPhone, go to the store and get an all black one for $5.60. You know what I mean? Ain't too many bitches in the city doing that, okay?
They been smoked out.
Got no insurance.
I'm BDO of all this sex money mercy that's going on this set. I mean, I'm BDO going to still in this motherfucker, man. I hear bloody, baby. I hear just they know what's poppin', bro.
Okay.
My whole brew here, nigga. Hey. You ain't not here, man. My whole brew here, man. TJ, man. Straight fuck up. TJ. Oh, she robbing or she bullshitting? She robbing or she bullshitting? Look at her hair, man. You with this loud? Look at her hair, man. Let me go get a room. Free my nigga TJ, man. I don't like this dick. I don't like y'all.
Yeah, man. I will find man. You know we things
like Pookie. Get on me.
That concludes the playing at 7:04.
All right.
As you see from the video, it is not just everyone in this entire video is claiming to be a member of, a part of Sex Money Murder, Your Honor. Again, a part of this gang that Mr. Williams, based on a cross-examination, has tried to disassociate himself with, when going through the tweets yesterday as if he is not a part. And we believe the totality of this video is something the jurors can look at and determine whether or not they believe Mr. Williams or any of the other, Trontavia Stevens, is a part of SMM and the Rock Crew, Your Honor. Okay.
I'm just having a tough time, Your Honor, reconciling. The state does not think that tweets made before and after Mr. Williams tweets things out are needed to give context to his words. But they, at the same time, they're going to sit here and tell this honorable court that some random person giving a 3-minute speech about what he has going on and about buying shoes for his kid if his kid asks, and about his baby having a car but she can't even walk yet, is needed to give context to things that Mr. Williams supposedly did on that video. Those two things, in my mind, cannot be reconciled, and I think that the state's arguments are shifting as we go from issue to issue. Perry does not relate, Your Honor. There's a case, Beach v. State, and it's plain error analysis, and ultimately they did not find for the appellant, they did not find plain error, but they did find that the prong of the plain error analysis, they found clear and obvious error to satisfy that prong, and that's 351 Georgia Appeal 237, and that's a case where 351 Georgia Appeal 237, and there's not, just to be clear with Your Honor, in the opinion, there's not a lot of analysis on the prong that I'm relying on it for, but they found clear and obvious error for just playing an entire tape, interview of the defendant into totality, and not redacting out irrelevant and prejudicial parts of the video. In that particular case, a prior incident was held inadmissible, but the statement made by the defendant in the tape referenced that prior act. The court held that it was clear and obvious answer not to redact, to eliminate reference to that prior act. It appears in that case himself and opened the door to his statement generally. but they said that references to the inadmissible act should be redacted. So the rule of completeness in just taking something that the defendant did and then just everything around it is automatically admissible, that is not the holding of Beach v. State. And as I said, the state's only presented U.S. v. Perry, which is easily distinguishable from this video. Thank you, Your Honor.
All right. Anyone else have any other argument in relates to 60W? Yes, sir.
Good afternoon, Your Honor. Good afternoon, everyone. Your Honor, I would just also, as the court's aware, as the court requires, I would have interviewed people in that video. I got it last week. We've been on trial, so I'll join everything else, but I just want the court to highlight that as well.
Thank you. Anyone else? All right. Can we, I have a question for the state.
Yes.
Is it possible to redact out the people that are smoking marijuana?
I mean, we can maybe stop and move it, but I mean, we can't remove them from the video. I mean, to me, Your Honor, that's not more prejudicial than probative. I mean, we have, in this case now...
Well, probative, it's not probative to anything that we have going on right here. I would, over the defense's objection, say that it's relevant. The tape is relevant. You've got several participants, and I'm sure, and assuming you lay a particular foundation, and that Investigator Belknap is going to be able to do that. But the people that are smoking marijuana, I'm concerned about that. That may be improper character. Those people, I mean, unless you, I mean, you got Walter Murphy, not Walter Murphy, but Mr. Stevens is, I mean, but the people that you don't know, that aren't, because I don't think there's anything that's charging in this indictment with marijuana, correct?
No, we do. We have several, we've already introduced several acts of marijuana, especially with Mr. Stevens having marijuana.
But he's already pled.
He has, and he's also already testified as well.
Yes. Well, what about the other people that are unknown that are in there?
Your Honor, we can send it to our graphics to see how we can try our best to put something over the marijuana smoking. Because there's a portion where Mr. Williams, I think, might be smoking when he comes into the camera view, so I don't know if we're going to be able to capture it.
Well,
But we can either stop or move past that portion where a group of people are just outside smoking.
I mean, there are several pieces of that tape. I think you're going to probably have to redact that tape because for what you have told me that you wish it's relevant to show, there's been an issue about the promotion of his career, but that you've got 4 you're accused in there, Mr. Williams, Mr. Murphy, Mr. Stevens, and Mr. Zachary. There are definitely sex, money, murder symbols and references to Pistol Pete. And Mr. Williams himself says that he makes some references to sex, money, murder. Those are all relevant, clearly relevant. But the other things that are outside of that, outside the 4 that are in there, unless the detective's going to identify everybody in there and show that they're tied somehow to to the gang or one of the other elements, what is he going to tell us, or what's your understanding as to what he's going to testify to?
I believe he knows who is the narrator of the tweet. I believe he can identify a number. I'm sorry, I said the tweet. I apologize. He knows.
He can identify people in the video?
He can identify people in the video.
Can he identify their affiliation, or what's he going to be able to do for those people?
So can I step outside and ask him?
All right,
Because I'm
going to take a 10 minutes, so I need to take a comfort break, and you can find out from that, okay? I'll make further rulings consistent with that.
You claimed you were at the house on Sturbridge Hill Road that entire time once you arrived there, correct?
Correct.
You said you went there directly from your house in Simsbury, correct?
Correct.
You didn't stop at Fort Jefferson Crossing, did you?
I did.
When it's not rush hour, it takes you from your home to get down to New Canaan back then. If there isn't traffic, what, about an hour and a quarter maybe? Is that about right?
About an hour and 30 minutes at least.
But you weren't there all day, were you?
Good morning, Your Honor.
Good morning, Your Honor.
My name is Jesse Dreiser. I represent Mr. Fernandez along with my law partner, Mr. Hill, who is present.
Good morning, Your Honor. Patrick Curdy for Ms. Gardner, and Mr. Baez is present on Zoom.
Thank you. Mr. Baez, can you hear us?
Yes, ma'am.
Okay.
Good morning.
Good morning. All right, so I passed this to get a status on the defense position.
Sure.
On the motion that was filed by Mr. Fernandez.
So on Tuesday of next week, we have our first deposition of the Secret Service agent who has coordinated a lot of this discovery that is sort of in dispute. And we have another deposition scheduled. The defense's position, knowing that the court and everyone would like a quick turnaround on this, was to come back the week of the 22nd to tell you that we're ready for you to assign us a neutral and independent magistrate of some sort. I hesitate to say, well, let's just do it the week of the 22nd, because a deposition could be canceled. We may learn that there's more discovery. As the court knows, there are so many issues that come up and may come up. And one we already are experiencing, which is we're having trouble accessing what the Secret Service has sent us, and our expert has been provided it, and he's working on unzipping that file, and we're working as fast as possible to get this to a point where the court can hear it. And
did any depots occur in the month of January? Because I thought you all were going to schedule a depots this entire month, and that's why I brought you back in February.
No, ma'am. The first depot is on Tuesday.
Does the defense seek to depose anyone locally, or was it a 2E issue with getting the federal agents to comply?
We did have to send 2E letters. There's a lot of lawyers. There's a lot of calendaring and schedule issues. The state gave us dates. They were very aggressive on making sure that they gave us time. The defense went through our calendars. I mean, I know that the court would have probably liked the depositions to be concluded, but I don't believe it's a lack of our effort. I can tell you that.
Okay. So on February 13th, you have one Secret Service agent scheduled.
Yeah, and then another agent who is intimately has knowledge of this particular issue is scheduled.
And another agent. I thought you were also going to take depots of who's the company, this taint?
On next week on the 13th.
Is two
When
witnesses.
I
I'm sorry.
provided their TUI letters. There's no TUI issue. These witnesses are absolutely willing to come. Secret Service agent, ATF research analyst, and I have made names and addresses for next point personnel and expert witness available to defense.
When the state says that there's no TUI issue, the court asked, did we have to provide TUI letters?
Right.
And yes, we did. They sent, Ms. Stifler sent us an email saying, you need to provide TUI letters. We had to draft, prepare TUI letters, get them to the state, and I made no indication that they weren't willing to come, but there was steps that had to be taken in order to get them to come.
I understand.
Okay.
I'm just trying to figure out what the process was, and then the next point person, that's also going to be done, or that's a different day?
It's actually someone from the Secret Service and someone from ATF, and they're both on the 13th.
Okay.
We can add, I mean, I've given them no dates. These witnesses are all on standby at any point they want to schedule a depot. We're willing to do that.
That's good to know.
So.
And is Ms. Gardner participating in these depositions?
We are, Your Honor.
And through the month of January, we were still being provided documents as to this very issue. And I think the court should know that as well.
Okay. So, just bottom line, you think that you would have some type of position the 22nd?
I'm hopeful, yes, ma'am.
Okay. All right, let me talk to you, Mr. Cody and Mr. Bias. Where does it stand with Ms. Gardner?
Your Honor, we're in a similar posture with respect to the motion to disqualify the state. We did file this week a bond motion, which we would like the court to hear. We spoke to the state about dates. We did propose the 27th and 28th of February. The state indicated that that was not agreeable to them. The state indicated they would like to resolve the disqualification issue before any bond motion was heard. Our position is that we need to hear the bond motion, that is separate and distinct from the motion to disqualify the state. And we'd ask the court to set a date for the bond motion so we can be heard on that motion and establish whether or not Ms. Gardner is entitled to a bond. We have now reviewed the majority of the evidence, or what we think we need to review to be in a position to file this motion. We do not believe that the state can meet the very high burden that's required to deny a bond for Ms. Gardner. And so our position, again, Judge, is we would like to have that motion heard.
And so you want the bond motion heard prior to the disqualification. Do you have any authority on that?
Judge,
Has it ever been?
I don't, and I did not know it was going to be an issue until this morning in speaking with the state, frankly, that would be their position. But I can research that if the court wants that researched.
I do.
Yes, Judge.
I think it's important. If you are alleging that the state has information or has done something inappropriate to warrant an extreme remedy to get rid of their entire office, I think that I'm interested to see if that's ever been litigated before.
Yes, Judge, I just make 2 points. The first is that it's not Ms. Gardner's fault that there was this whole next point issue, right? And she's been now held since August, and we had to do our due diligence before filing this motion so that we knew that it would be an appropriate motion to file before the court. So that's the first point. And the second point I would make to the court, that if the court finds that she is entitled to a bond, even with this evidence that they may not have it may not have been right that they had access to, then that bond would still stand and be appropriate. If the court found against us on the bond motion, but then disqualified the state, we would probably, reviewing again the case, find that it would be appropriate for us to refile the motion before a new state attorney and get their position on it, because the bond motion would have been completed with access to evidence they shouldn't have. My point is, Judge, either way, if the motion is heard before the disqualification issue is resolved, there is zero prejudice to the state.
Is there any thought by you that they would try to seek to present evidence that you're claiming that they didn't have access to in that hearing?
Judge, I don't believe.
That's what I'm trying
yes,
to avoid.
Yes, Judge, I don't believe so.
Okay. What's the state's position?
The state's position is that it would greatly prejudice the state of Florida, not necessarily myself or my office, but if they're going to have a bond hearing, the state of Florida is going to respond in kind with a motion for pretrial detention, both under the statute and under the Florida Constitution and State v. Arthur. We're going to attach evidence to our response. We're going to call witnesses. We're going to present evidence to the court to prove her guilt by proof evidence, presumption great. If we do not have a disqualification motion prior to that, and in the event that the court does disqualify the Fourth Judicial Circuit from the case after denying bond, it can renew that motion with the state of Florida and another prosecutor's office, which would then have to relitigate the issue, which is a burden on the state of Florida. It's a waste of judicial resources, and it greatly prejudices the state. My position is, and my position has been, the state of Florida has not accessed or has not used, read, or otherwise plans to use any information which is privileged. That's our position. That's what the hearing on disqualification is for. I believe we'll be successful in the disqualification motion, but I do believe that it would be greatly prejudicial to the state of Florida and the prosecution, whether it's our circuit or another, to have this bond hearing in the event that they can argue a substantial change in circumstance and then relitigate an entire bond motion in the future. I'm asking this court to set the hearing on disqualification in February after the defense has done their depositions, after we've had the independent administrator review a document that Mr. Fernandez's counsel and I dispute is privileged. There is no such dispute as to Ms. Gardner. Their motion is limited to the state of Florida potentially had access at some point to privileged communications which were never viewed or reviewed by anyone in law enforcement or the state. I want to have that hearing before this bond motion. Also, the state's going to file a written response. I'd like to do that sometime next week, give them notice as to what evidence we're going to present, what witnesses we're going to call. I'm not asking for a great delay. I think on the track that we're on, given any unforeseen delays, with the state of Florida having provided all this information to defense, assisted them with their subpoena ducus tecums and their TUI letters, making these witnesses available, I'm hopeful we can have this hearing on disqualification late February, early March, and I would ask to set the bond hearing mid or end of March. Ms. Gardner has been in custody since September. She did not waive extradition, so she was held longer in the state of Washington until she got here. She's entitled to her hearing on their motion. I agree with that, but I don't think she's prejudiced in any way in a delay of 1 month. They filed their motion this week. The state of Florida should have the opportunity to file motions in response and prepare for the hearing. The state of Florida also should not be prejudiced by having a disqualification motion hanging over our heads with statements by counsel that if the court denies bond, they're going to refile it and grant the disqualification motion. I think it makes the most sense, too.
I thought you all told me, and I'm speaking to Mr. Correa, Mr. Bias, that you all were reserving the right to amend the motion of disqualification based on any discovery that you all were conducting in the interim. Last time I saw y'all, we were in December, we're now in February. You indicated that whatever the cloud, what's it called?
Next point.
Next point. This was shut down for you all. You all were going to conduct the discovery, and you were going to amend potentially the motion that you were adopting based on what Mr. Fernandez. Am I understanding that correctly?
Judge, that is correct. We are still struggling, as is Mr. Fernandez's defense, in opening the information that we received from the Secret Service. So that's one hurdle that we're facing. The second thing is that we need those depositions completed to see how we're going to proceed with regard to this issue.
Okay. Well, to me, just practically speaking, to avoid any, if you all, in a hearing like this, not necessarily that they have to put on everything, they have to put on a substantial amount to meet the burden that you alleged in your motion. It's practically speaking, to avoid any discovery violations, or you're saying you didn't have it, they obviously can access it. You're saying you're having trouble with it. I'm just gonna...
Just one clarification. What they're talking about, I do not have access to. That's the whole point of the state's position. They received the unredacted versions of phone downloads. The state of Florida does not have possession of any of these. They got them directly from Secret Service. So I just want to be clear about that. This sort of drives me around. I had miscommunication with them this morning about that myself.
So you don't have access to what you're saying?
That's the whole point. They wanted it from the original teen agent. The state of Florida does not have access to these documents or files. I can't provide them to them or assist them in any way.
To be very clear, they have had access to the very documents and emails and the things that we've alleged in our motion. Let's not be confused about that. What they don't have access to is the unredacted raw data that the Secret Service went through before the Secret Service turned over all of our privileged emails to the state of Florida, which were uploaded to NextPoint. So,
well, that's in dispute.
Well, that's not in dispute. There is no dispute. Well, it's not. I mean, the emails that I sent my client sent me, were uploaded to NextPoint by the state of Florida. That there's no dispute. Whether they looked at them or intend on using them may be in dispute, but there is absolutely no dispute as to them being in possession of them. So, and it's a machinery issue. This